Welcome to the Berkeley Research Group Thinkset Podcast. I'm your host, Eddie Newland. Berkeley Research Group is a leading global strategic advisory and expert consulting firm, providing independent advice and dispute consulting around the world to corporations, law firms, government agencies, and financial institutions. For more, please visit thinkbrg.com. Today on the Thinkset Podcast, we'll speak with BRG Director Elizabeth Arnold. Elizabeth is an expert in BRG's labor and employment practice and has been advising clients on issues related to labor law compliance for more than 15 years. Elizabeth provides expert services to clients at leading law firms and companies nationwide in both a litigation and advisory context. Her engagements often include national research projects to determine the tasks and responsibilities of employees. On today's episode, we'll speak with Elizabeth about the gig economy and how companies can best cope with this evolving landscape. And with that, let's get started. Well, Elizabeth, thank you so much for joining us on the Thinkset Podcast today. How are you?
I'm great. Happy to be here.
There was a recent court decision, given your background, regarding Grubhub that I thought would be particularly important to speak about. It has to do with the gig economy. Would you mind giving us a quick primer on what exactly happened there?
Yes, happy to. There was a recent ruling in a gig economy misclassification case called Lawson v. Grubhub. And a lot of employers nationwide are looking at this case because it really is the first official ruling in recent years regarding how independent contractors should be treated in a classification sense. Now, there are a few aspects of the case that make it different, kind of unique, and need to be considered by employers because it means that it may not be applicable to other organizations. And that is the fact that, first of all, it was a single plaintiff case. So there was one individual who was a delivery driver, and he claimed that he was misclassified as an independent contractor when he should have, in fact, been an employee. So the issues that are reviewed with a single plaintiff are quite different than would need to be evaluated in a class action, for example. The other important factor in this case is that it's limited to California. So California's laws are somewhat different than the federal rules in this area. So employers need to take that into consideration as well when looking at this case.
As a native Californian, I think it's safe to say everything about California is just a little bit different. On that note, though, understanding that your guidance might differ even with colleagues within BRG simply because this is a complicated issue, how would you advise a company struggling to evolve with the gig economy?
Yes, we recognize that there are a lot of different types of firms out there and companies with different operations that are struggling really to figure out how their jobs fit into these job classifications that these days don't seem to really reflect the work that people are actually doing. So it's quite a challenge for them. One of the things that we recommend is that companies conduct an audit of the work that these individuals are doing. One of the key pieces of this that we recommend is really emphasizing data collection. So we really go out there and advise that companies either do it themselves or have an external group do it, collecting data from a variety of sources to help collect information that's relevant to making some informed decisions about classifications. So rather than just relying on secondary sources such as legal documents and paperwork, we recommend collecting actual data. So one method that we use for this is called the multi-source data collection method. And what that does is collect information from each source that's relevant to kind of the equation of the relationship. So one source of data is obviously the workers themselves. So we recommend collecting information from them. Multiple formats can be used, but some that we like to use include a structured interview where you're asking detailed questions about the individual's relationship with the company, different areas or aspects of control and decision making. So getting data from the individual worker themselves. But another thing that we do that's pretty unique is that we actually have conducted time studies or observation studies of these individual contractors as they're performing their work. And what that does is it enables us to actually collect quantifiable data, which measures the frequency and duration of contact that these individuals are having with the organization. So it enables us to demonstrate, for example, throughout a particular work period or shift, throughout an 8-hour duration, how much time was that individual actually interacting with the company, and what was the nature of that interaction? Were they simply relaying information, or were they receiving instruction? It's digging deeper into the nature of that interaction. And it's kind of thinking more about how is the concept of control broken down, and how is that actually exhibited by the company and the employee, and looking in detail at what that interaction looks like. So that gives us a really good source of information to provide the company. It results really in, from the time study piece, a measure, for example, in the 8-hour shift, say 5 minutes or less is spent interacting with the company, and the bulk of that interaction was all relaying information, for example. Or, of course, it could turn out that they're spending 90% of their day interacting with the company, and they're constantly asking for approvals and permission. So it can come out either way, but it'll really give you a picture of how the control is actually being exhibited or plays out kind of in the field. So that's one source of information. Another source is to kind of flip the relationship and looking from the other side, and that is from the company's perspective. So it's identifying the individuals that actually interact with the contractors themselves. So we call this group kind of the points of contact. And that can vary depending on the industry and the company itself, but there can be multiple departments or areas within the company that will interact with the worker, and the nature of that interaction could be completely different. So reaching out to one group, they could be getting controlled approvals or getting permissions to leave a package, for example. But then when they interact with another point of contact through the company, for example, tech support, they're really just getting some basic help with their handheld, for example. So recognizing the complexity of those interactions and the fact that control may be exhibiting itself differently depending on the party that the individual worker is interacting with. So looking at that, it's studying those points of contact and collecting data, again, using potentially a structured interview approach or observation, but really finding out how does that differ in the context of that particular organization. And then the last piece is really big picture of the company itself. One of the key aspects here that needs to be reviewed is what role does the worker play in the operations of the business? Is the worker providing the primary service that this company offers, or is it simply performing work that supports some side piece of the business? So it's really understanding the organizational structure, the operations, the objectives of the company. So to do that, we recommend speaking with higher level folks, operations people that are close enough to understand the operations, as in, for example, the software and programs that are used to control the flow of business, for example. So close enough to understand that, but also have a broad enough perspective that they can describe kind of company objectives and understand how the pieces fit together and how the business runs. So that's a high level description of one method that we've found to be very helpful, and we've worked with clients. And the result of all of that data together is a really comprehensive picture of what these individual workers are doing, how they're spending their time, how they're interacting with the business, and what role they play. So that would be one route that we would recommend companies or employers look into.
Now, I know BRG does a lot of this work in a litigation context where something's already come up, but I know, if I'm not mistaken, many companies are being more proactive with these types of assessments. Is that true?
You're absolutely right. So companies that see the writing on the wall and realize that they're potentially vulnerable or may have issues that they want to review with their classification. And again, this goes towards not just independent contractor classification, but other classifications as well. These firms are taking a proactive approach and are conducting these types of audits of their jobs in advance of litigation. So really looking at all of the key pieces that I just described, the worker's perspective, the company's perspective, and doing that in advance, which gives them all the information that they really need to make an informed decision about classification. And then should litigation arise, they already have a data set and a report and everything ready to defend the classification that they've decided to use. And that puts them in a much better position should litigation arise at a later date.
And this goes beyond just the gig economy, right? It applies to a lot of different FLSA issues that companies have to deal with.
Yes, that's right. So there are frequent FLSA and state litigation cases involving classifications such as the executive, administrative, and professional exemptions. Those involve similar job analysis to the method described previously, but are slightly different. The relationship is different with these employees, but it's a very important issue as well. Again, conducting a proactive audit of the classification of these employees, doing that in advance provides the employer with all the information that they need to make an informed decision about classification, and again, puts them in a much stronger position should litigation arise. They'll have all of their ducks in a row, if you will, to demonstrate that this was an informed decision and that this is a justifiable classification for their particular employees.
Now, shifting gears a little bit, I understand you're co-writing a chapter in an upcoming book. Could you give us a quick preview of what that's about?
Absolutely. We're pretty excited about this book. It's titled Wage and Hour Law, Guide to Methods and Analysis, and it's authored by my colleague, Dr. Chester Hanvey. And in this book, I co-wrote a specific chapter that talks about employee classification. And independent contractor classification is, of course, a big issue and a focus within this chapter. We talk about what the issues are in evaluating independent contractors, what's happened historically and kind of why we are where we are, and then what's going on generally with the courts and some key high-profile cases. And then we talk about some methods that organizations can potentially use to evaluate how their independent workers and employees should be classified. Now, of course, it's not a legal book. We're not attorneys and don't give legal advice. However, we do aim to collect data that's relevant to evaluating legal classifications.
Okay, that's a fair distinction to make. Taking a step back and actually touching on part of what you just mentioned there that the book talks about, now that we have had some recent movement on the litigation front, what trend do you think could take place over the next 5, maybe 10 years in this particular area?
That's a very interesting question. I think that there is another case pending in the California Supreme Court, which I know some cases are waiting to hear from, that might provide some guidance. And in the meantime, many actual local jurisdictions like cities and different states are developing their own rules to deal with this issue because, of course, it is everywhere in many industries, not just the gig economy. And so because there isn't clear federal guidance, many cities are developing their own rules and laws around how to deal with this issue. And I expect that will likely continue, particularly in big cities. They've come up with specific rules, for example, for shared drivers and how they should be classified because it is basically everywhere. I think that will continue. And meanwhile, things will move slowly on the legal front, I expect. But these rulings that are about to come out will likely play a significant role in how these cases are determined in the future.
Are there 1, 2, or maybe even 3, if there's more than that, cases in particular that you yourself are keeping your eye on that others should certainly make sure that they're aware of?
Yes, there's a Dynamex case that is moving right along, and there's lots of kind of speculation out there about how that case is going to come out. I have read some sources and legal experts that think that case is going to be ruled in favor of independent contractor, but it's difficult to say. But that case is going to have broader implications than this Grubhub case because it is a class action as opposed to the single plaintiff Grubhub case that we just talked about.
So it carries that little bit extra bit of weight, and being in the state Supreme Court obviously puts it on top. Well, Elizabeth, thank you so much for taking the time for chatting with us today. Given everything that's going on, I'm sure we'll check back in soon.
Thank you very much for the opportunity. Happy to be here.
This Thinkset Podcast is brought to you by the Berkeley Research Group. You can subscribe to the podcast and access other content from Thinkset Magazine by going to thinksetmag.com. I'm Eddie Newland, and thanks for listening. The views and opinions expressed in this podcast are those of the participants and do not necessarily reflect the opinions, position, or policy of Berkeley Research Group or its other employees and affiliates.